Welcome to the Successfully Retired podcast with Hamilton Brandenburg.
Today, we are joined by Meredith Ditchen Oakley. Meredith is an attorney that I met, and she's got a tremendous amount of experience, almost 30 years of experience in estate planning, family law, mediation, probate. So a wealth of resources and knowledge, and I'm just really excited to have you on the show, Meredith. Welcome.
Thank you so much. Thank you for having me. I'm very excited to be here.
Oh, man, it's so great to have you. Well, why don't you just tell our listeners a little bit about you and your background and your practice?
Sure. Thank you. Well, I've been practicing in the state of Georgia. My entire practice has been in the state of Georgia. I actually went to Marquette University Law School, and the day I graduated, my husband and I packed up a U-Haul and moved to Georgia.
That's so
So I
cool.
took the bar down here and started practicing almost immediately. So my practice has actually always been in Woodstock, and I've been a sole practitioner since 2001.
Wow.
So it's just me and my team. I have a fabulous team. And we, like, as you said, we focus on primarily family law and moving. We've always done a significant amount of estate planning and probate, but we're moving more in that direction. I think as our population ages and we're seeing a lot more, you know, estate need for estate planning. We have this huge transfer of wealth that's going on, and so we're focusing more and more on the estate planning aspect.
Well, that's huge, and what a great and underserved market. This is totally unscripted, but what brought you to Woodstock of all places?
Well, my parents, I've been following my parents around. I'm the oldest daughter, and so born and raised in North Carolina, where my mother was from. Lived there until I was in high school. My father then relocated to Chicago, so I went to high school in Chicago. Stayed close, like the dutiful first daughter. Went to Illinois State. Met and married my husband, and then when I was in college, they moved to Wisconsin. So what did I do? I relocated with my husband to Wisconsin to go to law school. And then they moved when I was in law school to Georgia. So we followed
Nice.
them down to Georgia. So that's how we ended up down here. We wanted to be close to family. And I've just been following my parents around. I told them if they moved again, that's it. I'm
That's
staying.
right.
They can do what they
You're
want, but I'm staying
you're
here. My
done.
kids were
No
all
more
born here.
moves.
No more. Yeah.
That's
So,
awesome. Yeah, well, you have a lot better, milder winters down here in Georgia, so we're glad to
oh,
have you for sure.
it was
Um,
either Central Illinois after law school or Georgia. We were like, yeah, Georgia. We're going to Georgia.
Georgia wins out in my book all day, but I'm a little biased towards that regard. So you've been working in estate planning and family law and probate. There's a lot of overlap. I feel like you're dealing with some of the biggest decisions and biggest, not just decisions, but biggest moments that families go through,
Yes.
and some of the worst times that people go through. I think about people who professions that see people and on their worst days. You have first responders, and then a lot of times you have attorneys who, outside of medical professionals, who see families in some of their toughest times and have to
Right.
deal and help them navigate those times. And I remember hearing a saying once that in life, the thing that gets most people isn't all the stuff that they don't know. It's all the things that they do know that are just not actually that way.
Right.
And I can't think of an area where there's, you know, maybe there are, but there's not a whole lot of areas where there's just more complacent misunderstanding than when it comes to estate planning. Have you seen that yourself in your
Absolutely.
practice?
I mean, I think there's a lot involved with that. I think it's doing estate planning is facing your own mortality. People don't want to think about it, and I totally get that. And then there's just so much, especially in the days of social media, right? I mean, so many people hop on, Nextdoor or Facebook to try to get legal information about
Yes.
estate planning, and I see all the time all of this totally incorrect information. And I when I talk to clients about estate planning, I'm always kind of shocked at how much misinformation is out there. And so I am a big believer in you can't make good decisions unless you have good information. And
Yep.
so I am absolutely passionate about informing clients and informing the public about the truth about estate planning and trying to help people kind of get over that hump with not wanting to I mean, they do want to do it, but they don't want to do it
Yes.
because it's, it's hard to do. And I get that, but
You go into Facebook pages and there's always somebody who's like, hey, so, I'm POA for my mom who passed away. And you just read that sentence and you're like, that's not how any of that works.
and then you
So
read the comments and it's like, no, I
yeah,
could make a full-time job out of going in and responding to all the misinformation that comes out online. And
yeah.
it's just like, go see an attorney,
Go
please,
ahead and
please.
go ahead and quit claim deed half of your house to your kid before you die on your deathbed, like all this horrible
Oh,
language. So
yeah.
tell us, what are some of the big areas, what are some of the big misconceptions that you see when it comes to estate planning?
A lot. Okay. So, first of all, I guess the biggest one that always surprises me is a lot of people don't understand that wills have to be probated.
Mm,
So, I mean, I see a lot people come in and they say, "Oh, well, I have a will and I'm the, you know, my so and so died and I'm the named executor." Um, and then I'll say, "Well, okay, so we have to probate the will." And they're like, "No, what? Probate? I thought probate was if you didn't have a will." So I think that's one of the biggest ones, is that all wills have to be probated.
what does that
Okay.
look like? So, I mean, everybody's heard of probate. It sounds scary, and you don't have to spend 20 minutes on it, but like, tell what is probate in Georgia? What does that really mean for a family to have to go through that? What's that process like on a high level?
Well, so I will say, I've been in practice 28 years. For probably the first 23 years of my practice, I always said probate in Georgia is not that big a deal compared to some other states. So one thing that's important to know is probate's different in every state.
Okay.
And so what probate looks like in one state could be totally different. And for years in Georgia, it wasn't that big a deal. Probate courts were very efficient, and they still are very efficient, and they're relatively inexpensive, very, very inexpensive, really, for the filing fees. I mean, I guess the biggest issue is that post COVID, it seems like the probate courts have gotten a lot busier. And so the waiting times to go through a probate have gotten longer. And there's
Mm,
just, anytime you're dealing with a court, there's just red tape involved, right?
yeah.
I mean, that's part of the process of dealing with a court. So um, the issue is that the time delay now, it's gotten a lot longer, and so it can delay things. I mean, I've seen in recent probates where there were some issues when the family tried to probate on their own, and it took 6 months to get the will approved and to have the authority. In the meantime, the children, because their mom had died, are having to pay the mortgage on the home and things like that, and it became a rather big hardship because they weren't able to kind of just jump in and handle things, which is why we're talking a lot more now about revocable living trusts in the state of Georgia, which can avoid probate. So that's one of the biggest issues, is just the time it can take in probating an estate now.
Yeah. So probate. So people think that because they have a will, because they went to rocketfreelawyer.com or whatever.
Yellow.com. Yeah.
Yeah, and filled out a form, which probably wasn't notarized or signed or anything. They filled it out though, and they printed it off, that now they can avoid probate. And then they'll get a big surprise when, even if it was filled out correctly and notarized and done by an attorney, they still have to go through this probate process before the individual who has concluded their retirement's able to pass on all of the assets to the people or the causes that they wanted to bless when they passed away.
That's
So
right.
that's
And
huge.
it's not even just about, I mean, probate does more than just pass the asset. I mean, you do have to have a way to pass the asset from, one person to the next according to the will in probate. But probate also awards that executor control over the estate. So
Yep.
nobody can transact any business on behalf of the estate until you've concluded the probate process and you get what's called letters testamentary. And
Wow.
so people are often surprised by that as well. And I will say, the other thing that I see a lot on, Cherokee Connect or anything like that is, you can do your own will. You don't have to have an attorney. And that is absolutely true. You can do your own will. You don't have to have an attorney, but I can't tell you how many times people have come to me with a self-drafted will when someone has died and they're having trouble in probate because some of it's not self-proving. We have self-proving affidavits and the affidavit wasn't done correctly, so now they're
Mm.
having to do all of these other things that you shouldn't necessarily have to do, or something that was written in the will wasn't translated correctly, or they didn't address what would happen if something was given to someone who was under the age of 18.
Mm,
And if you don't set up things like you can set up a trust in your own will to address how to handle those things. But if you don't, then you're going to have to set up most likely a conservatorship with the probate court,
mm,
which is very red tapey, right? Very
yeah,
involved with the court. You have to file annual, returns every year for that. And then the funds are released to that child when they turn 18, which is not generally what people want. Most people agree that 18 is not old enough to manage a significant amount of money and that they're probably not mature enough. You don't have a choice. You just lose control over things if
sure.
you don't address them yourself, so a lot of
So
people
people,
don't know that they need to address those things in the will they've self-drafted, right? You don't know what you don't know.
absolutely. So people who have just done a will, especially if they've self-drafted and maybe they didn't have an attorney really explain to them what is this going to look like in execution, might face a situation where they the process takes longer than they thought it would, requires more paperwork, is more intensive, and maybe even doesn't quite follow what their wishes would have been if they had
Right.
spent some time with an attorney really talking through what's important to them and how they want their uh, beneficiaries to be blessed once they've concluded their retirement. So that's huge. So what's another big misconception you see when it comes to estate planning?
So I guess another one is what happens if you don't have a will, right?
Yep.
A lot of people assume that if you're married, everything just automatically goes to your spouse, and that is not the case in the state of Georgia. So, without a will, basically, the state of Georgia decides for you how your assets will pass, right?
Mm,
And a very common situation that I run into is, let's say you have a more traditional, a stay-at-home mom, a working, the husband is the one who is out working, and the husband passes away, and because he was the one working, everything is pretty much in his name, right?
yep.
So it's very common the house to be in his name because the mortgage was in his name, and they never got around to transferring the house to both names. Okay. And so at husband's death, then without a will, that's going to have to go through probate with or without a will. It's just that now the state of Georgia decides how that's going to pass. And so, according to the state of Georgia, it's going to go to in equal shares to his closest living heirs, which is going to be a spouse and his children. So, if these are
Mm,
minor children, the house is now owned by the case that I was involved in. It was a wife and then two small children, a 3-year-old and a 6-year-old, right? So they each owned a third of the house. The children actually owned more of the house than the wife did. And
whoa.
because they were minors, then in the probate court, a guardian ad litem was appointed to represent their interests, right? And so, mom isn't able to sell the home or downsize it or use all of those funds to purchase another home for her and her children because the children own 2/3. And those funds have to be set aside and maintained for the children in a conservatorship set up by the court, which ended up being very costly and time consuming. And an hour with an attorney preparing some estate planning documents could have saved this family a lot of headache and heartache in the long
And
run.
I'm sure every good estate planning attorney would much rather work with the couple to prepare the will than to work with them on processing fees and court documents for conservatorships. Like
Absolutely. And I mean, I
that's
tell
a much
people all the
better way to
time,
make your living.
I mean, my goodness, it's so sad. The saddest situations I've seen have come out of the lack of estate planning, honestly. It can be worse than family law as far as family conflict and things like that. So I tell people, even if for the diehard people that believe, you shouldn't have to hire an attorney, draft your own will, let me at least review your will for you
Yeah.
that you've self-drafted so I can give you some heads up as to things you might want to look into or think about. The other area that I often see that people are shocked, they'll come in and they think they have everything lined out. I want this and this, and then I'll ask questions. Well, what if this person is predeceased you, right?
Yeah.
Or what if, and people are great about planning for, here's what I want done, but they don't always think about the what ifs. And that's what I'm trained to do, right? Use my experience to look at all the situations that I've seen and try to preempt those situations and do some preventative planning so
Mm.
that, if that situation happens, your family doesn't fall into, that, whatever that is.
I like to ask that question a lot too. When we're working with new clients, we review their estate documents because we want to make sure that what they've done drafts what they're telling us their wishes are. Because if not, it's time to go back to an attorney and get it redrafted. And we also look at their beneficiary designations. And a lot of times we'll ask them, okay, husband and wife are on there, and husband leaves everything to wife, wife leaves everything to husband, and then they have backup beneficiaries. If they're really diligent, they have backup beneficiaries of their kids. It's called contingent beneficiaries.
Right.
And there have been situations where sometimes an adult child sadly predeceases a parent,
Right.
and that adult child had children as well. And so now you have mom and dad, 3 kids. The 3 kids all have kids. Oldest daughter dies, dad dies, mom dies, old beneficiaries. And so now you have a situation where everything that's left over, it becomes a question to these clients of does it
Yeah.
go to the 2 kids because one of
Right.
them predeceased, and now essentially maybe the heirs of the 3rd kid are completely cut out of the
Right.
inheritance
Right. You've had a
because
failure of the named beneficiaries. It's like, what do you
yeah,
do?
because they didn't. And sometimes that's as easy as literally just saying, hey, could we make a small note on your beneficiary designation that this follows per the lines or per stirpes, if that's what your wishes are. So
Yes.
they're just little things that get missed, or people think, hey, it's good, I check the box once I'm done. But we go through a process to re-review our clients' estate plans every couple of years, and to just summarize them briefly and make sure they still understand them and they still match their wishes, because these things need to be updated over time as your time and your wishes change. um, I've seen a lot too, and I'm sure you can speak to this. A lot of people, this is just a very basic misconception. They think, I don't need a will because I don't have a lot. I have a very simple situation.
Right.
Everything that I own has a TOD on it or a beneficiary on it. And so
Yes.
I don't need to do any estate planning. Where do
Right.
you see the problem with that?
Well, I mean, again, probate and a will does more than just pass the asset, right? It provides someone to be in charge, someone that you trust to
Yep.
transact business on behalf of your estate, which can be dealing with utility companies. It can be, processing, refunds from your health insurance, or dealing with your final illness, your funeral bills. All those things still have to be addressed, even if you don't have assets to pass. There's always going to be business that has to be transacted after your death. And so, that's another thing that this person in that role, personal representative or executor, is appointed to do, is transact business on behalf of the estate, right?
That's
um,
huge.
that's huge. That's huge. And something you said triggered something for me that I see all the time. Another really common misconception about adding children to your bank accounts, right? We're talking
Oh,
about beneficiaries. And this comes up all the time where someone says, hey, I've got 6 kids. And I want everything to be split between my 6 kids. So I added my oldest daughter to my bank account and she's going to split it up. No. Well, she might. Okay, maybe that's great, but she could have gift tax issues if she does that, because when you add them to the account, then they are the legal owner at your death. And then if they choose to give it to their siblings, that could be a taxable consequence. Depends on how much. I mean, I don't do the tax part. That's why
sure.
I refer back to you, but that's not what you generally want to do, is add a child to the account. They could have power of attorney on the account if you want them to be able to help you transact business, or you could maybe add them as an authorized user, but not a co-owner. And also not you don't generally want to add your children to your real property as well prior to your death. There are ways to do that. So there's just a lot of misinformation out there, and people do it, but then they're surprised if their child gets sued for a car accident and suddenly their property then is at risk in satisfying some sort of huge judgment or something like that, or their child has to file bankruptcy, and then
Yeah.
that real property is at risk. So there are all these things that people just don't look into the future, and it's not that they aren't. They're very savvy and have thought to do this planning, but it's the what ifs that
They just didn't realize that there were some sharks in the water that they couldn't
That's
see.
right.
There was a case that I heard about a year ago of a family in Pennsylvania, and mom added her adult son to her bank account. She didn't have a lot of assets. I don't know that she did, but my understanding was it was kind of like, hey, we're going to add him to the bank account to make this easy for us to transfer everything to him when I pass away. And adult son passed away before mom did.
Mhm.
Pennsylvania has a state inheritance tax, Mom
Oh,
ends
yeah.
up paying an inheritance tax to get back her own money.
Yeah.
So that's a bit of a one-off, but depending on your situation, if you're just playing the Google cowboy, getting on the internet, thinking what are the good ideas that are out there, and you don't check
Right.
with a professional who has expertise in your jurisdiction, you could be exposing your assets to inheritance tax, to
Mhm.
like you said, to creditor risk from somebody who
Third
rear
party
ends someone
creditors.
else,
I
and
mean,
now they're
all
getting
kinds of,
sued. I've
yeah,
seen
you really are
I've
exposing
seen
yourself to a lot of
inheritances locked up in
unknowns.
during COVID, locked
Yeah.
up in probate for or not for over a year because the person who passed away was in a lawsuit and his estate was being sued for a huge chunk of the inheritance. So all these weird things can happen when you start putting other people on bank accounts and real assets, trying to find a way to skip out on paying an attorney a few $1,000 to do planning and leverage their expertise can cost you tenfold or more sometimes what
That's
it
right.
would have just costed to have it done right the first time.
Easily, easily. And the other thing that people don't think about, I often hear, oh, well, my kids will work. I mean, that's, I tell people, don't name co-executors. Don't you ever give, I'd never recommend that somebody says, I leave my house to my two kids. Don't ever, that's where we see the most conflict in estate planning is unfortunately like siblings after this mom or dad is gone having to make a decision together about what to do because one of them wants to rent it and make it an Airbnb and one wants to sell it and then the roof goes out and they have to pay for it and one has the money and the other doesn't and then one wants to remodel and there's conflict. So we say, say the house has to be sold and the money split. They're not going to argue over that. And if one of them wants to buy it from the estate, let them go ahead. But the
Sure.
default would be let it be sold. We have one thing that people don't think about. They say, oh, my kids get along great. There won't be any issues. Well, what if your child has predeceased you and you're not dealing, it's not your two children dealing together. It's, the representative of one child's estate
Yep.
or their conservator versus the sibling. I mean, that's not, doesn't necessarily matter that the kids get along because it may not be the kids working together to make that decision.
Yeah, 100%. Yeah. Do you want to turn your children into Congress? I mean, Congress is great. We love that they have to argue and work together to pass laws because that forces compromise. Also takes a long time. Do you want your kids to be in that role where they have to potentially ruin Thanksgiving because they're arguing about what did mom really want when she was very vague on her wishes? Or maybe one kid's just in a tough situation. They need the money more than the other. And so it just opens up a whole hairy can of worms to have co-executors on an estate who have to agree on everything, especially if you're not very, very clear with how you want things done, and
Right.
very specific. That's great. Any other final parting words on how people can be more proactive in making sure that their estate plan, even if it's already completed, matches their wishes and is up to date?
Well, we recommend that you review and update everything. Probably at least always, if you have a change of life event, right? Somebody passes away, or even gets married and has new family members involved. Even if there have been no changes, I think it's a good idea to update some of these documents every 5 years or so. And the reason is that things like the advance directive and the power of attorney are based on your consent. So when you're using those documents, you usually can't confirm your consent because you're unavailable, you're ill,
Yep.
something's happened. And so if those documents are 15 years old, the third parties that are accepting them get a little uncomfortable.
Mm.
So check up on things, update them. Also, if your power of attorney was done prior to 2017, it's no longer valid. We had new power of attorney forms that came in 2017, and the older forms are not being accepted any longer. So if you have an estate plan that was done prior to 2017, you need to have your power of attorneys checked and update them.
Well, this has been a really tremendous use of time, Meredith, and I learned some new stuff that I think will be really helpful in conversations with families and helping them get specific on their wishes and making sure they truly understand their estate documents and when they need to bring them back to an attorney to have them re-reviewed. So this has been great. Thank you so much for joining us, and I'd like to have you back on sometime. This podcast reflects the personal opinions and viewpoints of the host and Brandenburg Financial Services. The information presented is not a comprehensive analysis of the topics discussed, is general in nature, is not personalized investment advice, and should not be construed as a recommendation to purchase or sell any particular security or strategy. Guest appearances on the podcast do not represent any endorsement, level of expertise, recommendation, or any affiliation with Brandenburg Financial Services. The views reflected are subject to change at any time without notice. No representation is made as to the accuracy, completeness, or relevance of the information presented. This podcast may contain information that might assist you in the development of subsequent discussions with the appropriate professionals and should not be construed as investment, tax, insurance, or legal advice. Therefore, please consult your financial, tax, legal, and insurance professionals regarding your specific situation. Any forecasts or forward-looking statements are based on assumptions, may not materialize, and are subject to revision without notice. Past performance is not indicative of future returns. Investment advisory services offered through CS Planning, an SEC-registered investment advisor doing business as Brandenburg Financial Services.